most of the judicial officers are drawn from. You look into the statistics. What are the communities from which they are representing? I don't know how many tribals, how many Dalits, how many minorities are there in the high courts and supreme courts. There are 800 district judges posts are vacant. There are 200 high court judges posts are vacant. We expect them to deliver. For every public interest litigation that we win, there are 100 other cases in which courts are deciding against the rights of the people. We only look at the PIs. PIs are very important. I am not denying that. But at the same time, I see that pro-people oriented judgments are an aberration and status quoist judgments by the judiciary is the principle, is the rule. Finally, I want to end this with only one statement. The Indian judiciary never had any philosophy of its own, philosophy of justice of its own, apart from that of the executive. Up to 1980s, when socialist pattern of society was the established or the ruling philosophy, the judiciary gave one kind of judgments. After 90s, whatever you present, that is the policy of the state, we have nothing to do with that. They completely forgot what is there in the constitution. There are several instances in America where the judiciary could take a stand which is completely against the philosophy of the ruling class. But we don't find that kind of instances except very rarely in Indian context. If necessary, we need to take the legal battle beyond the boundaries of criminal justice system, and to influence the judiciary, we should also bring pressure through agitations. That has been done in Andhra Pradesh. Through agitations, the even judiciary was influenced, and the people who were spearheading these agitations, they also used the judiciary to get positive orders to defend the rights of the marginalized. That is the only way it worked there. I can't say that it was completely successful, but when we think within the confines of legal framework, our success will be very limited. And finally, I want to say only one thing, especially about prisoners. If we talk in terms of needs and wants and entitlements of the prisoners, that will have very limited appeal to the people, especially the community which is completely against the rights of the accused or the prisoners. We need to articulate the rights of the prisoners in terms of justice and injustice. That will have a connecting point with the other side of the table. Otherwise, the community will continue to demand for instant justice, which is very dangerous for democracy. Thank you.
Dr. Woodley, absolutely brilliant. Absolutely brilliant. Not needs and entitlements and wants and so on, but justice and injustice. And to understand where this statement comes from, we must understand the Andhra Pradesh human rights movement. Human Rights Forum is one of the most respected organizations in Andhra Pradesh. And there's another organization called the Andhra Pradesh Civil Liberties Committee, which probably is the largest human rights organization in this country. And it's not like other human rights organizations which are NGOs. It is a mass movement organization consisting of students and tribals and others. And it covers every district of Andhra Pradesh. So Andhra Pradesh is actually probably, Punjab will come close, 2 or 3 other states will come close. but truly a mass human rights organization kind of situation. And when he says that we are not restricted to law alone, Human Rights Law Network is not of law, and sometimes they forget what is the most important thing. He's absolutely right. You have to look at law, you have to look at outside the law in terms of struggle and movements and so on. And Dr. Murli, the only thing I would like to request you is at the end, once everybody else has spoken, just see if there's something that we can do. Sorry for bringing you back again to the law. If there's something that we can do again for the under trials in Andhra Pradesh, if there's some way in which we can break through this thing and try and release a large number of these tribal and Dalit under trials who are rotting in the prisons of Andhra Pradesh, if there's something that we can do. But thank you very much for coming, thank you very much for speaking, and thank you very much for giving a perspective in this program. Devashish Banerjee from Kolkata. I'd like to welcome on the stage now Kiran Singh from the Lawyers for Human Rights International. And I'm so sorry, it was by omission that it didn't come. But again, the Lawyers for Human Rights International is one. I'm just giving you this introduction for those of you who are not familiar. I think it is probably in terms of state level lawyers, the largest network of any state in this country. Andhra Pradesh would probably be number one, but I think Punjab is number two. Where in every district of Punjab, there are lawyers who are working for the poor. And not like an NGO. Not like an NGO, where you pay a person and say, okay, I'm giving you a salary every month, and you do legal aid work. It's not like an NGO. It is just lawyers who immediately, if I do it here, I talk enough, get in and say somebody is called from so-and-so place. Within an hour, a person will reach that person. It's totally outside that NGO framework, that funded framework. And it's a way where lawyers dedicate themselves to providing legal aid for people in police lockup and prisons. It's also a very outstanding organization which has a political standing. Political standing not in terms of parties and all that, but in terms of ideological view. Social viewpoint. So it's a leader in the Punjab. It's probably the only organization in the Punjab which has that kind of standing. Thank you very much, Kiranji, for being with us today. Yesterday you spoke on the death penalty. Today we'd like to see what can be done in terms of the other issues, particularly under trials. Our focus is to some extent on the pitiable conditions of under trials.
Hello everyone, I would continue to talk about law because I have been requested to speak about the judgments that we have protecting the rights of an accused person at the point of arrest. After this Kasab's judgment has come, it's really very complicated for us that whether a person has a right to a legal aid lawyer right from the time of arrest or not. But as I see the Kasab's judgment, subject to corrections of all the lawyers who are present here, that the Supreme Court has not done anything new in Kasab. The Supreme Court has said what the Supreme Court has said earlier also. Yes, a person has a right to a legal aid lawyer from the day of production. This is not something new. The Supreme Court is kind of putting more stress on that. But the Supreme Court is not discarding at the same time that the person does not have a right to a legal aid lawyer from the time of arrest. While the Supreme Court has decided in these judgments earlier that yes, the right to legal aid is present from the very threshold of arrest. To start with, I would just like to next slide, please. Next slide. Joginder Kumar's case has dealt with a lot of issues, but what I would like to put stress on the fact that the police should not arrest arbitrarily. Joginder Kumar probably is the first case where the Supreme Court is observing that until and unless it's absolutely necessary, the police should not arrest. The police should issue a notice, call for the person in the police station, and only if arrest is kind of unavoidable, the police should go on with arresting the person. It's saying that except in heinous offences, arrest must be avoided. Prem Shankar Shukla, D.K. Basu are some of the judgments where the Supreme Court is observing about some certain rights that the person arrested has, that we most of us know about. D.K. Basu is important on this point because D.K. Basu is reiterating the issue that the person arrested should be informed about the grounds of arrest and his right to consult a lawyer. So this is at the time of arrest, the police should inform the arrestee. Prabhadat's case says that the media person especially has a right to interview a person in custody. This includes police custody as well. Sheila Base is probably one of the most important judgment in this aspect. I will come to Nandini Sarvati's case later. Sheila Base says very importantly that whenever a police, though it's kind of strictly based, a Maharashtra-based judgment, and this judgment applies to the state of Maharashtra only, but Sheila Base for the first time says that whenever a police arrests a person, the police should immediately inform the nearest district legal aid services, district legal aid committee, so that a person, a lawyer, can be immediately engaged for this person who cannot afford a lawyer of his own. Sheila Base continues to observe that whenever preferably a lady judge should conduct a surprise visit of all the police stations so that the persons inside the police lockup can initiate their grievances, if any, before the judge. Shobharam's case back in 1966, it's very important. It observes that the right to counsel applies at all custodial interrogations and at all critical stages of prosecution after formal proceedings have begun. Which if we kind of interpret, would mean that once a person is arrested and taken to the police station and custodial interrogation is beginning, from that point of time the person has a right to a lawyer. And if the person cannot afford a lawyer of his own, obviously that would mean that he has a right to a legal aid lawyer at state's expense. Khatri says, in Khatri, the Supreme Court says that if a person is denied of his right to legal aid at the stage of trial, the trial would vitiate. Which again the Supreme Court in Kasab's case has kind of observed on the contrary. Nandini Sarvati's case, I think it's, for me, it's very important because the Supreme Court has categorically dealt with all these stages. And it says, you can see in the slide, the observations of the Supreme Court. The right to consult an advocate of his choice shall not be denied to any person who is arrested. Lawyer's presence is a constitutional claim in some circumstances in our country and also in the context of Article 20, Clause 3